You may have seen that Giuliani has been ordered to pay $140 million in a defamation case. So what's that about? Well, I thought I could just give you a little bit of a background to that particular case, but more usefully, it's an interesting jumping off point to chat about things generally. So what's the situation? Giuliani was being sued by two election workers who he accused of being part of rigging the 2020 elections. So he accused them of all sorts of things, stuffing ballots, passing memory sticks around with dodgy information on, and he also put out, or at least re-put out, an edited video with a commentary that suggested they were up to no good. They got a lot of abuse about that. As you can imagine, it's quite a hot topic and very contentious, the election result in the United States. And, you know, they had to move house, they were being harassed, they were being chased, they were receiving death threats. So they sued for defamation. Now, Giuliani and his lawyers, they didn't actually defend the case. They didn't comply with disclosure or anything like that. So the claimants, or plaintiffs as they would be over there, they obtained what we call judgment in default. And that's my first jumping off point. Because judgment in default is something you get where you issue a claim and the other side just don't respond to it. So it's judgment in default of a defence. Sometimes, like in the US, you can get judgment in default even if people file a defence but then don't comply with court orders or court directions. Over here we'd call that a strikeout, but it has the same effect. So effectively, he couldn't contest liability. Now, what's interesting is his lawyers took I think it's quite a sensible approach to this, because when you obtain judgment in default in a defamation case, there still has to be a hearing to assess the damages. Now, that's different from if you just put in a money claim, so-and-so breached a contract, he owes me £100,000, and they don't defend it. You get a piece of paper that just says, they owe £100,000, and you can just go away and enforce that. And judgment in default it's an administrative procedure over here in England and Wales. It's not even a judicial one. You just send the requisite form off to the court office and they just check, see if anybody's filed a defence, and if they haven't, they just issue the piece of paper. But when it comes to defamation, and that is the same here, you still have to prove that you suffered a loss, that you suffered damages. So that's what the hearing was about, and the claimants, the plaintiffs, they gave evidence as to what the impact had been on their lives. And damages were actually assessed by a jury, an 8-person jury. Over here they wouldn't be. Now, like I say, I think the lawyers took a sensible approach, because they started out by saying, yeah, we accept it's all wrong. Hands up, we made a mistake. However, we don't think we are responsible, or our client is responsible, for the consequential harm that occurred. Yes, we got it wrong, but we can't be responsible just because people get angry about it and start issuing death threats. And our client will go into the witness box or on the stand, take the stand as they would over there, and explain everything about it, and why he thought that was the case, and why it was all public interest. So they shouldn't really get any damages. Having said that, he then basically, and this is something lawyers we always dread, it's like, yeah, we've run in, here's our best way of doing this is damage limitation, and then your client A does not then go into the witness box, but instead stands out on the courtroom steps in front of all the press, repeating the defamatory allegations. And that's the sort of conduct that you can draw attention to. Over here you can get aggravated damages for that, because you can say not only should we win, but the conduct of the defendant during the trial, in other words, constantly repeating it and constantly accusing them as liars. I mean, he didn't even do it in the hearing, though. That's, so that probably went down even worse, because it's not like he could be cross-examined about it. He refused to take the stand, just went on air saying all this with nobody able to challenge him. So as a result, like I say, they've been given they've broken it down into general damages, specific damages, punitive damages. Now, technically speaking, and if I remember when I get in, I'll edit the actual what's called a verdict form in there. At the moment, we only have a verdict form, so that's not yet a judgment. the judge will go through that, check the sums, check it all adds up, and then will issue a judgment, which is a court order, and that's when Giuliani becomes liable. Now, people have said, oh, well, all he's got to do is go bankrupt and he can avoid this. However, where judgment debts arise out of either deliberate or malicious conduct, then they're not dischargeable in bankruptcy. Now, there might be an argument about this. I mean, obviously he'll appeal this anyway, but I don't think he'll have much of a chance, to be honest, because the appeal court's likely to say, look, you had your chance. You didn't even attempt to defend the initial hearing, so why should you have a second bite at the cherry now? But one issue will be, is this a judgment arising out of deliberate or malicious conduct? In which case it's not disclosable in dischargeable in bankruptcy. And you may remember this from that other trial, oh, that seems a long time ago, where there was the issue about the bankruptcy, but also whether the insurance policy covered the legal expenses, because it excluded liability for any deliberate or reckless contact. So, yeah, like I say, there you go. So that's the situation with the Giuliani trial, but I just thought it might be of interest to people generally, because judgment in default, a lot of cases end up, being determined by judgment in default because the other side just don't engage in the process whatsoever. So it is a useful thing to have, actually. And in this country, if a claim is issued, you have 14 days from the date the claim was issued to respond to it. Now, you can file what we call an acknowledgement of service. And that just basically says, yes, I've got the paperwork, and you can tick a box saying, going to defend it, going to admit it, going to partly admit it, going to admit it, can have a bit of time. That buys you an extra 14 days. That gives you 28 days to respond. If you do need more time for a defence, you can ask the actual claimant and say, look, I need a bit more time to do this. And you can agree between yourselves to extend the time by a further 28 days. But after that, you would need the permission of the court. Because in the old days, before they set very strict timetables, cases would drag on for years and years. Quite often, one thing you could do, you could apply for a case to be struck out for want of prosecution. In other words, they haven't actually, basically they've issued this claim, this is for bumper defendants, and they've not done anything with it. We're just sat here, we've not responded, they've not got back to us. It's interesting also that they use the word prosecute there, because we all say, oh, sign saying trespassers will be prosecuted. You can't prosecute civil matters. Actually, you can, and the terminology does reflect that. But yeah, it's a great thing to do. Issue the claim, check with the court office, hello, it's 14 days now, have you heard anything from my proposed defendant? And if they say no, say, right, can I have a judgment in default? And it's like, oh, there you go. If judgment in default is issued against you, you can apply to set that aside, but it's quite a strict test. I mean, basically, you've got to show you had a good reason for not responding. As soon as the judgment, you became aware of the judgment, you acted promptly in trying to set it aside. And we're talking like, within 48 hours. And also, you must have a good defence, more than just an arguable defence. They have to look and say, actually, yeah, you're in with a punt here. So the standard, the threshold is a lot higher for setting aside judgment in default. If you are ever running out of time, it's better to bang in a quick application for what we call relief from sanctions, or an extension of time, because then the test is slightly lower. It's a slightly lower hurdle to get across. So yeah, anyway, there you go. As always, hope you found that vaguely interesting, vaguely useful. I mean, that could be something that actually could be useful, because it does occur a lot in civil litigation. This is Wheal Unity, Wheal, W-H-E-A-L. Wheal in Cornish just means place of work, but it's commonly associated with, the old mines, so they're all like wheel something. It's very nice. I won't go in there because there is another sign saying dangerous building, but just to give you some idea of the scale of this thing, it's pretty big, isn't it? I really like it, but like I say, I'm not going to go that far into it anyway, because it does say dangerous structure. It's lovely in there though. Right, there you go. See you next time.